Once again, I would like to welcome us to today's webinar. My name is Joshua Adepetu, and I have the pleasure of serving as your moderator for this insightful discussion on alternative dispute resolution, the legal and social political aspect. Today, we are honored to have with us
Again, I would like to
Professor
welcome
Isaac
us
Albert,
to
a
today's
distinguished
today's
scholar
webinar.
and expert
My
in
name is
conflict
Joshua Adepetu, and I have the pleasure of serving
resolution.
as your moderator for this insightful discussion on alternative dispute resolution, the legal and social political aspect. Today, we are honored to have with us Again, I would like to
Professor
welcome
Isaac
us
Albert,
to
a distinguished
today's
scholar
webinar.
and expert in. Excuse me for that break. Projects for that. So today, we are honored to have with us Professor Isaac Albert, a distinguished scholar and an expert in conflict resolution and alternative dispute mechanism. He is a professor of African history, peace and conflict study, and the pioneer dean faculty of multidisciplinary studies in University of Ibadan, Nigeria. He is a peace and security analyst. He had his PhD in African history at the University of Ibadan in 1994 before training for peace processes at the United Nations International Leadership Academy, Amman, Jordan, and other parts of the world. Our speaker for today is a member of the National Standard Committee of Nigeria's Tertiary Education Funds, that's the Fund on Research and Development. He is the editor-in-chief of the African Union African Journal on Terrorism. He is a fellow of the Nigerian Academy of Letters, a fellow and board member of the Society for Peace Studies and Practice, SPSP. Likewise, he's a fellow of the largest mediation institute in Africa, ICMC, and a fellow West African Peace Builder, Accra, Ghana. He is the author of the book, one of his latest books, Mediating for Peace in Africa. Distinguished participants, I encourage you to stay tuned, take notes, and actively participate in this webinar. And after a session, we'll be having a question and answer suggestion from the participant. Without further ado, I would like to invite our distinguished speaker today. Please join me as I welcome Professor Isaac Albert. Your Excellency, you're welcome, sir.
Thank you so much, Mr. Moderator and my brother. Let me welcome all of us, Your Excellencies, distinguished personalities, ladies and gentlemen. Well, once again, I think I have to thank ICMC for always inviting me to its programs. And I particularly delight in this particular one because it forced me to reflect on my many years of work as a mediator, student of mediation, and participant in high-level mediation exercises globally. I came into the field of mediation in the early 90s, 1993, 1994. And I was dragged deeper into it in 1994 following the regime of Abacha and the interest of the international community to build our capacity in mediation exercises. Now, this presentation that I'm making today, to me, is more of a reflection of my encounters in the field. So some of the things I'll be saying, you may not find in books, but they are products of the challenges that I met in the field. And I therefore decided to research around them and then make them available to you as my submission. Now, I sent my PowerPoint. I don't want to project from here. In the first slide, I tried to define alternative dispute resolution. And I think I will be addressing an assembly of people who are beyond the usual of, definition. But we still have to do it. We are saying here that alternative dispute resolution is any attempt we make to manage conflicts outside traditional litigation. To me, as somebody working closely with security operatives, I want to say what we call non-kinetic approach. Your refusal to use force in military operations could also come under ADR. So ADR is very broad. It includes what our traditional rulers do, even what our parents do. So in understanding alternative dispute resolution, we need to go beyond what is taught in the classroom or what we do in our workshops. But formally, we say it is anything done outside the court of law. And it includes negotiation, conciliation, mediation, madhab, arbitration, and other forms, including mini court trials and so on. Now, we are celebrating it. Please let me take your permission for coughing. I'm just back from field work. I went around Nigeria, and I think I brought back cough from some of the rural communities I visited. Now, we are giving so much attention to it because it takes shorter time and to do. It is cost effective, it is flexible, and informal. It helps to preserve relationship. It's based on expertise that might require more of our native intelligence, and it is confidential. Now, we have two issues to address in this presentation. The first aspect of the paper has to do with legal aspects of ADR. And I'm happy that you included legal aspects in the topic, because most of the time, some of us, including Professor Albert, will say that ADR is more of what people who are not lawyers, non-lawyers, what they do. But this topic is forcing us to recognize the fact that there are key legal issues in ADR, which, if we overlook, could mess up the outcomes of our work. And I call attention to four key issues. The statutory framework. In any society, you have laws and regulations governing ADR. Yes, you are free to do ADR, but ADR is not something illegal, and therefore there must be some legal, inputs into it. So laws and regulations that govern ADR, such as arbitration, conciliation acts, and of course we are familiar with our own Nigerian society, most especially what happened in 2023 when we had the Nigerian Arbitration and Mediation Act 2023. And then the issue of jurisdiction. ADR does not cover everything. So ADR's applicability varies by jurisdiction, with some courts mandating ADR before trial. For example, in Nigeria, a dispute resolution clause provide for mediation as an enforceable, part of our legal system. Then, principle of confidentiality, ADR often ensures confidentiality, protecting sensitive information, and so on. Now, I move swiftly to the next slide, where I call attention to what I consider to be the core issue when we're discussing legal aspects of ADR. And the first thing I try to call attention to is authority to negotiate. When we say we are negotiating, what authority do we have? So we have now authority to negotiate refers to the legal and delegated power granted to an individual or entity to engage in negotiation on behalf of another party, organization, or government. This authority determines the negotiator's scope and limitations. Let me give a very good example. If my wife decides to negotiate on my behalf, is she right to negotiate on my behalf? And if she has to negotiate on my behalf, how far can she go? And then what are the limitations? Now, understanding authority to negotiate is essential for effective representation, building trust, and achieving successful outcomes. Now, what are the sources of your authority to negotiate? We have constitutional provisions that enable some people to negotiate. For example, a minister could go out and negotiate on behalf of his ministry. Then you have statutes and laws, specific laws dealing with specific problems. Then you have government regulations. Government regulations generally, we are not referring to the real constitution, which is the grand norm, but regulations created by some agencies. Then you have organizational policies around which could give one the power to negotiate, and then delegations of authority. Some people, an individual is delegated with the power to negotiate on behalf of others. Now, we need to take some things into critical consideration. When we are negotiating, most especially on behalf of any person, we need to clarify the issue of authority scope and limitation. So, for example, if you come before me to negotiate on behalf of your parents, I need to ask a number of questions, whether you have the authority to actually do what you are trying to do. Now, for me to be sure, or for me to ensure that you have the authority for what you are doing, I may ask that the issue of authority is documented. You write it down, that you have been authorized by your father to sell this house. And then we need to also communicate authority. You let people, you convince the other party that you have the authority to represent your group. And then you respect authority boundaries. What we're saying here is that, yes, I've been authorized to negotiate on behalf of my group, but the authority that I have is not limitless. The authority has to work under certain conditions. I will come to this issue later. The next slide. Types and levels of authority. Now, I call attention to 3 types of authority. There is what I call actual authority. explicitly granted by the principal. So if I'm coming to you to negotiate on behalf of my group, do I have explicit authority to negotiate with you? Now, for those who are lawyers, if you are representing your chamber to negotiate with another group, you must show convincingly that you have been granted the power by your principal. The second one is apparent authority, which is implied through circumstances or actions. There are some situations that does not leave room for proper documentation, information that you need for actually having 100% authentication of your authority. I mean, there could just be, under such circumstances, you can just claim to be representing the group because it's a state of emergency and then you are recognized. Then the third one is implied authority, which is derived from the negotiations position or role. I come to a meeting and, we want to negotiate and somebody says, do we have somebody here representing the academia? And I stand up and I say, I'm a professor of whatever from University of Ibadan. And they said, okay, we have somebody here from the academia. So we have these types of authority, but having the authority is also not to say that the power you have is limitless. So we have authority levels. And the first one is what I call full authority, unrestricted decision-making power. So I tell you at the meeting that whatever we say here, whatever we do here is final. I will ensure that the outcomes of this procedure is carried out. Then you have limited authority. Limited authority is that, yes, you are representing the group, but you are bound by some specific parameters. I don't want to take us too deep into this, but going deep into it will take us into what we call constituency in negotiation. You have bureaucratic constituency and you have unilateral constituency. Bureaucratic constituency is saying that I am in this meeting to represent ASU, but whatever agreement I reach with you is not binding until I go back to the Congress of my association. And it is the Congress that will authenticate it. So that is called limited authority. Now, you all will recall that Nigeria once had what we call Bakassi Agreement with Cameroon. But the conflict in that particular historic event is that, yes, Nigeria had that agreement with Cameroon during the Nigerian Civil War to say if Cameroon could help us protect that flank from being used to bring arms to the Biafra, that we will give that part of Nigeria to Cameroon. But by that time, as we still have it, Nigeria was a bureaucratic constituency. When you had, if that type of agreement took place, there was the need to bring it to the Supreme Military Council to be authenticated. Now it's like Nigeria giving any part of, it's like the head of state giving any part of Nigeria now to any country. If that is not taken back to the National Assembly for ratification, it is not an agreement with any strong authority. Then the third one is advisory authority. The outcome of that negotiation will only help we only serve as recommendations to your principal. It is not the final agreement. Now, the next slide talks about Authority to mediate. Authority to mediate. Now, the point I'm trying to make is in discussing authority to negotiate, authority to mediate, authority to arbitrate, is to say that you can't just jump into any of these activities as if there are no regulations, there are no legal issues for you to mind in actually jumping into them. So authority to mediate refers to the recognized power or legitimacy of a mediator to facilitate negotiations and resolve disputes between parties. Now, what are the types of mediation authority? You have legal authority, which is derived from law, statutes, or court appointments. So in this case, the mediator is recognized by the law. Then you have contractual authority, which is established through agreements or contracts with the parties. Then you have institutional authority, which is granted by the organization or institution. For example, when you are establishing your partnership, you might want to build mediation into the terms of the partnership. And you are saying that should there be any conflict, we would adopt mediation in dealing with the issue. And so once the parties, the two of them appoint a mediator, that mediator is said to be having institutional authority. And then the last one, moral authority. This is based on expertise, reputation, or trust. For example, if you have problem in your neighborhood, you might just look for one person that is respected by everybody, and then you appoint the person as your mediator. Now, sources and levels of authority in mediation. You know, where do mediators get their authority, their powers from? We're discussing, this is a broader thing now. You can have the power from international organizations, and I cited AU and ECOWAS. And I'm sure you are familiar with African Union's panel of the wise. African Union's panel of the wise. And then at ECOWAS, you have ECOWAS Council of the Wise. You know, these are people who can actually come in to help people. And then you have national governments. The national government could play the role of a mediator. Nigeria can mediate between Ghana and Sierra Leone. You know, that is, you know, when you're, you know, if it's on the international scene. But within the country, the government can actually constitute, you know, a panel of mediators to go into some problems. Then you have courts and tribunals. You know, courts can actually institute court-mediated, and then tribunals, and then professional mediation organizations like ours, ICMC, can actually intervene in conflicts. And then you have community or cultural leaders. Now, authority level in mediation, you have binding authority, you know, decisions are enforceable. And I think you have this more in arbitration, because arbitration is broken into two major parts: binding arbitration, non-binding arbitration. But mediation, it's difficult for you to force anybody to accept outcome of mediation, except if it is the court, you know, recognized type. So non-binding authority, recommendations, or just guidance, you know. So your decisions are just like recommendations or articles to guide the parties. Facilitative authority assists parties in reaching agreement. Now, key considerations and capacity building. What I'm trying to do here is to link what we have said so far and what we are doing to what ICMC is doing. Now, generally, we want to take a look at some considerations. Neutrality and impartiality, we have been taught that. Expertise and knowledge, that is what, the capacity we build every day. Credibility and trustworthiness, we are told at our training programs. And then communication and interpersonal skills. We teach all this. But we are teaching all this to prepare us to strengthen our capacity, to strengthen our authority. And now, it all boils down to the issue of capacity building, training and certification. When we train people, we are not just training you because we don't have the time. Because we have the time to spare, but we are training you so that your authority base will be, strengthened. And that is why we have different levels of certification in ICMC. But I laugh when I see people who have gone through 2-3 days training, calling themselves chartered mediators. Mediation, after your initial training, is more a product of your experience in the field. I've been doing this since 1994. I'm still learning. I don't call myself a chartered mediator. This is because one mediation, the mediation you did yesterday is most likely to be different from the one you do today or the one you are going to do tomorrow, because it's different from litigation, which is based on written laws, codes that people read, understand, and apply. In mediation, you have to keep improving on your systems. Then neutral and impartial stance, how to make you to be a neutral third party, how to build your communication skills, and then establishing mediation frameworks or organizations. Now, the next one is authority to arbitrate. Here, we are saying authority to arbitrate refers to the power or jurisdiction granted to an arbitrator or arbitration panel to resolve disputes between parties, sources of the authority, contractual agreements, parties agree to arbitration in a contract, statutory provisions, laws governing arbitration such as the Arbitration and Conciliation Act, court referrals. Court may refer disputes to arbitration. Requirements and limitations. Now, you must have clear agreement to arbitrate. You must be familiar with the relevant arbitration clause. Your jurisdiction over the dispute must be you must understand it and be clear that you have the jurisdiction. Then your principle of impartiality and independence of arbitrators. Limitations, scope of arbitration, jurisdiction limits, public policy consideration, and then in some cases, conflict of law. Now, if you don't have authority, you will end up with invalid arbitration awards. And then judicial interventions might make nonsense of your efforts. And then you might lose credibility as an arbitrator. This is because you have not used your authority well. Now, let's go to the second part, which is socio-political aspects of ADR. Now, here, we are saying we are looking at ADR, not necessarily as something that is, totally legalistic. It is non-adversarial. You are trying to bring people together to deal with their problems. And then the aspects include community-based dispute resolution, cultural sensitivity and awareness, traditional dispute resolution methods, social norms and values influencing ADR. Then you have economic aspects. We know that ADR promotes cost saving and efficiency, economic empowerment, job creation and employment opportunity, impact on local economies, and so on. Now, power and structural impact. Power dynamics. We are told that power is the architecture of mediation. Then balancing power imbalances in ADR, representation and advocacy, negotiation strategies and tactics, gender and diversity considerations, addressing systemic inequalities. You see, what we're trying to say here is that when you are mediating, you are taking into consideration many things that the court of law might not take into consideration. You are conflict sensitive. That is the word. You are conflict sensitive. If one of the parties breaks down crying, there are strategies for managing what we call ventilation. So there are several things you have to take into consideration that enables the parties to keep the power with you. Because the moment they discover that you are not fit for their system, they will withdraw the power and withdraw from the process. Institutional and structural aspects, court-connected ADR programs, institutionalization of ADR in organizations. I think we've discussed part of this when we're discussing. Now, some emerging issues. Up to today, there are some people that are still critical of ADR. So you have critics, ADR as an alternative to justice. Some people still doubt the credibility. Some still don't want to be part of it. Then some people say it is an attempt to privatize justice. Then some people will tell you that it promotes inequality, and for us, we think that it bridges gaps in inequality and access to justice, cultural appropriation and sensitivity, ADR's impact on social change and activism. So we're saying here that ADR is very, very important. It helps the society, but we have people that still come up with arguments against ADR. Now, understanding these issues help. For example, if you appoint me as a mediator, there are many things I consider in the process which the parties might not be conscious of, or which even the other mediators, the co-mediators might not be conscious of. Because I know that it is a very sensitive thing. So I'm not just throwing my weight around. I'm not just using any careless language. So it's like all your senses, all your sensory organs are brought into the system. Now, understanding these issues help us to improve ADR's effectiveness and accessibility. What I'm saying is that if we are conflict sensitive, if we are careful when we are doing our mediation, your effectiveness is improved. It addresses power imbalances and inequality, promote cultural sensitivity, and so on. Now, the challenges and future directions, because I know the time is not on our side. And I think here I will say the last thing first. The last thing that I should be saying before concluding this presentation is to say that in the process of my participation in mediation exercises, whether at community level, whether at state level, whether at international level, I realized that we non-lawyers must work closely with lawyers. There are certain things that come out very fine in the process of the mediation, but that may not be legal. Then there are some tactics and strategies we may need to use, but that may in future put the mediator into trouble because of the deficits in when you apply those things to law proceedings. Now, having said those last things, let me call attention to the challenges and future directions, and then I will close. I still think that there is limited public awareness of mediation. Several people are not aware of the value in mediation. I'm saying this not about the general public. Many lawyers do not know the values in mediation, or do not want to know the values in mediation. And the question for ICNC is, how do you close that gap? How do you close that gap? Then we still have problems with enforcement difficulties. I've mediated in many community conflicts in Nigeria, and I've written 2 books on some of these projects. But the question is, there is a mediation exercise. It worked very well. The parties sang your praises and they shook each other and so on. But in 2-3 years, you see the conflict coming back. And when you move very close to them, you discover that the problem is enforcement difficulties. Third, some mediation exercises over the years produce what one would call power imbalances. Mary Anderson, in his book, Do No Arms to Development, is saying that we should not engage in any practice that would, in the future, put some people to disadvantage. So the question is, how do you deal with the issue of power balances? And the last point I want to make, lack of standardization. We still need to standardize what we are doing. For example, I know that ICMC is into online mediation now, but I'm yet to see any report on what is coming out of that process and the extent to which the procedures can be standardized. Then, mediation has limited appeal mechanisms. So future direction, what do? We need to use technology. We need to invest more in training. We need to encourage government support. We need to expand ADR in specialized areas. And then we need to promote public education and awareness about ADR. Thank you so much. Over.
Prof, thank you so much. Thank you so much, Prof, for that for your insightful and thought-provoking presentation. Even despite your health condition,
Yes.
we truly appreciate the wealth of knowledge and practical insights you have shared with us today, and we wish you quickest recovery, sir.
Thank you.
Thank you so much. We have in the house earlier. I saw our past president, distinguished Dr. Agada Elachi. Your Excellency, thank you for joining. So before we have 1 or 2 comments from our elders, I would like to ask if there's any question. If you have a question, you can either drop it in the chat box or you make use of the raise hand feature. There are several comments coming from the chat box. Thank you so much, Prof. This is coming from Bridget Osakwe, from Rahim. Thank you, sir. So if you're having any question, you can type that in the chat box, or you make use of the raise hand feature. So while waiting for that, I don't know if so while waiting for the question and answer, please permit me to bring up Dr. Agada Elachi SAN to give us a good message on this. Excellency, please can you unmute, sir? Okay, we have a question coming from Bridget. Please expatiate on getting the collaboration with the lawyers. Bridget is asking, sir, that please expatiate on getting collaboration with lawyers.
So,
and also we're having
collaboration with what?
with lawyers
Knowledge.
on how with lawyers how mediators can collaborate.
Okay, with lawyers. Well, I mean, when I started my career and I came into ADR, I was then in the habit of telling lawyers that they should face their litigation. And why we will focus on mediation and the rest of them. But I helped to manage a very difficult community conflicts in Nigeria. And that conflict started in 1845. And we succeeded in ending it in the year 2002. It was a very tricky, a tricky intervention that took us up to 1 year. But it produced excellent results, and that conflict stopped. But during the mediation exercise, the two communities agreed that a new local government council should be established. That was part of the agreement. And they danced, they did all that one would consider to be very good outcomes of the mediation exercise. And then I drove to the office of the governor of that state and told him that we have succeeded in solving the problem. And there was to be a very big do I call it celebration? And it was a very big event that we're planning, where all the parties will come together, say, end this conflict, and so on. So when I went to the military administrator, so the man clapped. He clapped for me. And he said, this is an excellent intervention. He said, the next thing for you to do now is to go and create the local government. And I was surprised that throughout that mediation exercise, there was nobody that could remind us about the constitutional provisions for establishing a local government. Now, I faced several problems like this across the country. Something that you think is minor, later you discover is major. And then sometimes you are mediating, and you discover later that the mediators or the parties to the conflict that were part of this thing had no authority. No authority. Because you come to the community, you think the traditional ruler is the person in charge of the community. But at the end of the exercise, you discover that the traditional ruler has no power. Hello?
Please proceed, sir.
So when you work closely with lawyers, it helps you to understand the situation better. But sometimes I also laugh when I see lawyers also training on community conflict. It's more tricky than some of the things I see people doing. It's a very complex thing. When you say community, what do you mean by community? In some cases, community is not just referring to a town. You have what we call community of interest. You have different types of communities. It could be a youth movement. You need to understand the community itself. It's not just a matter of putting two people together and they sit in front of you and they are talking. These people you are dealing with have no authority as far as that community is concerned. So every community has its own characteristics that can only be understood through rigorous sociological, investigation. So it's not as simple as people they just do, and then they say we have done training on community conflict management. It's not as easy as that. Now, the point I'm trying to make is that I came to know about the significance of law and lawyers through my own experience in the field. I came to understand the complexity of the word community through my engagement with, I was discussing with people recently, this idea of community policing. They say we are doing community policing in Abuja. And when I interact with people sometimes, I realize they don't even understand what they are saying. They don't understand what they are saying. And the problem of policing is not as people present them on the surface. So what we are trying to say is that nothing stops ICMC, for example, from doing special trainings on legal aspects of mediation. We are not telling them to teach us law, but conflict sensitivity, the role of law in conflict sensitivity, that you don't just jump into some of these problems as we often say or do. But I don't also see anything wrong in lawyers that want to work on community conflict to sit down with those who would teach them what constitutes community and how community conflicts are managed. Community conflicts are very complex to manage. In fact, it can lead to loss of life. They can beat you with juju. I'm sorry that I'm going this deep. It's not as simple as I see people doing all over the place. So there's a need for us to deepen our knowledge of some of these things we're doing. And when we do it, when we deepen our knowledge, we produce better results. That is the point I'm trying to make. Over to you.
Oh, thank you very much, sir. Thank you for that wonderful response to the question. I think the last question will be coming from Madam Ellie Kali. He said, please, sir, can you throw more light on the bindiness or otherwise of mediation? Please throw more light on bindiness.
You see, in mediation is a voluntary thing. And then when you are talking about the outcomes binding, you are saying the parties must comply with the outcomes. That is not for mediation. The parties will consider it binding by suasion, by through voluntary acceptance of the procedure, through voluntary recognition of the mediators, and through acceptance of the outcome of the mediation as something needed by the community. I've done a mediation that ended with the two sides taking votes. It's not as easy as we think. And the vote that they have taken is the one that will make the outcome of the mediation binding for them. But a third party cannot force them. Even in arbitration, you differentiate between binding arbitration and non-binding arbitration. If the procedure was done under non-binding arbitration, you can come up with your whatever and they'll say, no, one party could just get out of it because it's non-binding. But if it is binding, so mediation is, the summary of what I'm saying is that mediation is a voluntary exercise, and that is why we say, whereas the authority of a judge is in the laws and statutes of the society, the authority of a mediator is in the confidence that the parties have in you. The moment they no longer see you as being credible, the moment they think you are partial, they will simply take their things and walk away, and you cannot arrest them. And that is why recently we're studying a problem in one of the states. Some people an institutional mediation exercise. The woman came and said, I told my husband to come, he refused. And then they look for somebody to go and bring the man. That is not mediation. You cannot call it mediation. You cannot go and bring the man. So if you want to bring the man, then you come under the adversarial system. The woman will report normally, or the woman will sue the man, and then the man is served notice of, is invited. So if the man doesn't come, then the court has procedures for processing such a person. But under mediation, you don't send somebody to go and pick the man. When I saw that aspect of it, I just stood up, I went away. And I told my students that with me, I said, well, I'm happy that this system is producing results in the sense that it is decongesting the courts. But these people should stop calling it mediation. That is my own academic opinion. I may not be right.
Thank you so much, sir.
Yeah.
Thank you. Thank you so much, Professor Isaac Albert. It's been awesome with you. Your deep dive into legal and social political aspects of ADR has truly enriched our understanding on this topic. Thank you so much. In fact, we can't even thank you enough. There are several comments in the chat box that I may not be able to read all of them to us. Earlier, I told us that we have the past president of the Institute, His Excellency Dr. Agada John Elachi, SAN, is with us and we would like to hear his good. Your Excellency, good afternoon. Good evening, sir. We would like to hear from you. Please.
Good evening, Prof. My distinguished teacher and mentor.
Good evening, sir.
I have to leave. I have to step out of the Supreme Court to join this webinar. I
am highly honored, sir.
Thank you so much. Respect I have for you, sir.
Thank you so much, sir.
Thank you for a very well delivered lecture as always. And I want to congratulate everybody who joined this particular webinar because Prof is a reservoir of deep knowledge. And not just an ADR practitioner, is a peace scholar and an expert that there's no comparison to. So, Prof, thank you again for making out the time to sacrifice and to let us learn at your footsteps. And I assure you that those of us who are your students and mentees will continue to offer ourselves every opportunity to learn from you. On behalf of the Institute and everyone else, we say thank you to you. And I wish everyone a wonderful evening and a pleasant one at that. Thank you.
Leonard, thank you so much. Thank you. It's wonderful to hear from you, despite the surrounding things surrounding you. But thank you, sir. Prof, thank you so much. Our past president is asking, Dr. Brown Louis is asking, will we be present? Are we going to send? Should we send the presentation, please? He's asking if we can get the presentation, the slides.
Please send the presentation to everybody.
Oh, great.
I sent it to you. Give it to anybody who needs it.
Great, I will do that. I will send it to everyone participating in this. Thank you so much. Thank you so much. So quickly before we sign out, I'll just have some few announcements for us. The biggest ADR conference in Africa, proudly organized by ICMC, has been scheduled to hold on the 26th of November 2024. So if you're a member of the Institute and you're yet to register, you have less than 24 hours to enjoy the early birds because the early bird will be closing tomorrow. For associates, the registration fee for members, fellow, and guests. And if you also want to register out of the country, you can visit www.icmcconference.org or you make payments to the account details that is displayed on your screen. Then after doing that, you send your full name, your email address to support@icmcng so that we can proceed with your registration. you can proceed with your registration. So this announcement is for our members who desire to upgrade their membership status. We're already rounding up on our training calendar for the year. We have few more trainings more. The next one is mediating workplace conflict, scheduled to hold on third and fourth. I'm sorry, on the 2nd and 3rd of October. So if you like to register for this course, I will encourage you to make payment and do the necessary. So distinguished participants, once again, I want to say a big thank you for participating